To shall or not to shall? Hello, legal eagles. This is the question for today. Do you shall in your contracts, in your legal opinions? You remember when we were in high school, we were told only to use shall in the first person singular or the first person plural, like, shall I make you a cup of coffee or shall we go for a walk? Never in the third person singular. I'll tell you why. I learned about it only at university. It's a threat. If you use shall with a third person singular, for example, or you're threatening somebody. Like, if I were to say, you shall do the homework, I would be implying I have some kind of a divine power to make you do the homework, which unfortunately I don't. So, who can shall? Definitely, for starters, God. 10 Commandments, thou shalt not steal. Okay, the Queen of England, the King of England, the Parliament, the courts, the state can shall. That's why all the legislative acts have the word shall in them. And the lawyers, yes, natural lawyers, because they represent all the above mentioned people and people, God as well. And lawyers would put shall in the contracts because somehow this would imply that the contractual provisions and obligations would be enforced later on by the state. So, do you shall? Please bear in mind that the word, the shall, or like 10 Commandments texts is not the freshest piece of legislation, right?
Simon, come on in. I have a question for you. No, you need to see this. Look at this. This is so funny. Is that some sort of joke? Nominal in the first paragraph, pagination on the left-hand side, Times New Roman, stupid little feet walking all across the page. And what's that word?
Shall?
At this firm, we instruct, we advise, we order, we must, but we do not shall.
It's not really
Why must we must?
Because we thrust, we don't parry.
Do you shall? I do, sometimes. When a client requests it, of course, but I always inform the client about the risks involved in using shall in the documents that I translate. Let's listen to Simon Porter, yes, the one from writtenlegalenglish.pl, our favorite legal English teacher from Warszawa. He's got some very, I believe, good insights into how shall works these days.
What's the problem? It's the frequent misuse of the word shall in legal documents. Why is this a problem? In legal language, shall only has one legal meaning, to have a duty to do something. In other words, must. If you think about shall as expressing an obligation, you won't go too far wrong. However, legal drafters frequently misuse shall, and as such, shall has often ended up before the courts. The courts have then had to interpret shall to work out what the drafter actually intended, as the actual meaning of shall isn't clear in the applied context. In ruling on these cases, the courts have understood shall as referring to the future, in other words, will, giving permission, in other words, may, or being directory or giving general advice or guidelines, in other words, should. The word shall can therefore mean 4 different things, even though it only has one legal definition. The resulting confusion has led to numerous cases. Not only do we have to think about shall and its multiple meanings, shall is used when there's absolutely no need for it to be used. What's the solution? Don't use shall. Use either will, must, may, or should, depending on what message you're trying to communicate. Or use the correct form of the applicable verb if you think shall shouldn't be used.
Right, Simon, got your message. When we use shall, we enter treacherous waters. But do we? If shall does have one legal meaning, maybe it's perfectly okay to use it in contracts, for example. Well, let's have a look at something I've prepared for you. This is the research I did as a side job, actually, or no, it's not a side job. It was a side effect of the translation project I did for one of the law firms. We translated the amended bankruptcy law, pre-pack provisions, because the law firm felt that the provisions available online, you know, the legalis system, were maybe confusing for the clients. But I want you to do it with me. I want you to log into your legalis system right now, put in the search window the word bankruptcy, open the first document that shows up, and follow me. Go ahead. So, Polish bankruptcy law is translated by Beck and offered by an online database of legal acts, legalis. Article 56a. The application for approval of the terms of sale shall show the terms of sale. Obviously, in Polish, it's a must. Then Article 56e. The trustee shall enter into a contract. As you can see, the Polish structure is present simple. Article 56e. The contract of sale shall be entered into. The Polish meaning of the word is may. Article 56g. The court shall rule. The Polish structure is may. Article 316. The bankrupt's enterprise shall be sold, and the Polish word is should. Communication in English, to be effective, must be clear and precise. And the contracts that your client signs must be unambiguous. Anything less than that is unacceptable. You will agree with me, right?
This ultimately highlights my point. Shall is by nature ambiguous. If you use shall, you will cause the reader problems. On the other hand, though, if you're representing a client in your home country and the dispute is based on the contract written in English, and you see shall, it's a gift which may help you to interpret the contract in any way you see fit.
What Simon refers to are the guidelines of the plain language movement. I endorse them wholeheartedly. But of course, I do realize that you will be using shall in different forms in different texts. Please share how you use shall in your law firms and whether perhaps you have some doubts about its efficiency, efficacy, or maybe we could just drop it from the legal texts. Thank you. Thank you for watching this video. Bye.